Well, we have given her a couple of minutes. I think we know that she'll come in, so I think I'd like to start this meeting, call this meeting to order at 1:03 p.m. Thank you and welcome. And we have Trustee Abdoli on Zoom and Trustee Katz, who is very close to being in her seat. So shall we do roll call?
Sure. President Srinivasan,
Present.
Trustee Abdoli,
Present.
Trustee Yu,
Present.
and I'm Trustee Nakatani, and I'm here. And I think Trustee Katz, as you said, is probably just a couple minutes away.
All right. May I have a motion to approve the agenda?
I move to approve the agenda.
I'll second it. All in favor? Aye. Opposed? All opposed? Okay. So now we go to public comment, and the board recognizes the value of public comment on educational issues and provides this time for members of the public to address the board. Each speaker is requested to identify him or herself and to address the board once for up to 3 minutes on this item. And at this point, we have one public comment. Do we have any other public comment that has come in via Zoom? None via Zoom. All right, well, Mr. John Moriarty, thank you for being here. Come on up.
Thank you. So,
Come on up.
do we need to stand or?
You can pull a chair up if you're.
Great.
Just, yeah, there you go.
Thank you. Thank you for the opportunity to address the board today. I'm here as a private citizen and providing some comment on the proposed bylaw amendment for the CBOC relating to the Form 700. So I'm also on the CBOC and in the past week have reviewed the Form 700 and did some research and also reviewed the 2 legal opinions provided to the board relating to the fact that it's not legally required to be in the bylaws. So from a public official perspective, the CBOC members are not public officials. And in looking at the onerousness of the Form 700 and looking at it from my perspective, and I believe the forms have been noted as being due today, Thursday, March 30th for the CBOC. And in terms of completing that form, the categories of information that are requested are incredibly burdensome and very, very broad. And I'm concerned about the chilling effect that may have on the current membership of the CBOC and over time as the CBOC members cycle off and cycle on in terms of getting the broadest representation possible from the community to fill out something that's not legally required. And I understand that CBOCs in California, some choose to have a bylaw requirement similar to the one that's currently in effect in Mill Valley. Some choose to not have that requirement. And going back to Measure C in 2009, I think it's important to note that this board faced a similar situation where the exact same bylaw provision was in the bylaws for that bond measure. And then the board subsequently recognized that that made sense to delete that. So I would ask that this board, follow similarly and modify the bylaws accordingly. Thank you.
Thank you very much. Do we have any other public comment that has come in this time? Okay. So we have a singular item here today, and I just want to remind board members that we are going to first see if there's any additional information that is provided by the district. We have received, as has the public, a summary and from our legal, and we also have legal available. Thank you for being here from F3 should you have any questions of them. Once we receive any additional information as needed, then we will go into question session. If you could please work to having no more than 3 questions per board member. And I think we'll do this in kind of a round robin fashion. It'll hopefully go more quickly. And then after that, we'll have discussion. And the discussion is a place where you can also advocate. As you know, this is somewhat of an unusual situation we've never been in before, where we have a board bylaw that was approved September 15th by the old board, of which 2 of your members here were party to that board, and have now had a request to revisit the bylaw. So does anybody have any questions about that before we begin? All right, at the very end, I will ask for a motion to either approve a change or a motion to keep the bylaw as is, all right, and that's how we'll vote.
Do we need a motion for both? We need a motion to change, obviously. If we don't do anything, is there still a motion?
My understanding is that we do. We have an attorney here who can maybe guide us to that question, to that answer.
So in order to maintain your bylaws as is, if you were to keep the status quo, you legally would not need board action. I think for the purposes of the minutes, we would want, clarity as to, the board's decision and consent to maintain the status quo. And so by virtue of making the board action and to keep the status quo, I think that would just help for the record keeping purposes. But because this is your approved CBOC bylaws, there would be no legal requirement to essentially reapprove the bylaws as stated.
Okay, so what I'm hearing is that if during the discussion and advocacy section, board members will be sharing their thoughts and ultimately their advocacy related to a possible vote. And what I'm hearing you say is that language should be in the minutes, or are you suggesting that we vote so that it's clear what our position was? Could you give more clarity on that?
Yes, so let me restate. So legally, there is no obligation for the board to make a motion and vote to keep the status quo bylaws, because those are the bylaws that are already in effect. However, because it has been presented essentially as a question of whether the board wants to revise or maintain, for the sake of clarity, even if it's so for the sake of clarity, if the board, I think making a motion to maintain status quo and affirming board's intent and just kind of codifying the board decision and discussion as to why the board has decided to maintain the status quo, I think would be beneficial in this instance to ensure that all of that information is reflected in the minutes. But again, to state, it's not out of a legal obligation, because the bylaws as stated would already and continue to be in effect. And so you wouldn't be changing the bylaws, but it would just be reflecting the board discussion and board affirmation that even after this discussion, the board has made a motion and decided to keep the bylaws as is and to continue to maintain the Form 700 filing requirement.
Thank you very much. And now with that, let's open it up to questions. And if I may begin. So I thank you for the emails as well. We had emails from Dr. Rollins, the Monday following the Thursday meeting, where it became through conversation and we have that on tape with the CBOC meeting, that there was a request for the board to revisit the Form 700 specifically. So we have an email on Monday and other emails, and thank you, Dr. Berman, for your most recent email where you provided additional information from Dan Miller regarding Form 700 and possible next steps should this board decide to keep the bylaws as is. For background knowledge for myself, what I want to understand is we have a process in the district, which I'm familiar with because I have filled out this form twice, or and we'll 3 times now, with a due date that I had for April 1st. And I received information from the district a month ago with a follow-up on March 17th. So can you share with us if the CBOC members received this same information? I understand that they were provided some documentation on March 17th, but if they received the same guidance and support from the district per this particular form that we are to fill out.
So the forms are collected by Anna Russell in our office. Right now, there is no category on our filing forms for which category CBOC would fit. And so in subsequent conversations with the county office of elections, we have learned that the date of those submissions may be set here internally and likely held internally. and they would need to represent a 12-month disclosure. So for that reason, Anna did notify through the agenda that there was the current requirement for the 700 form from these individuals. There was question as to when that would be due. At this time, a due date of November is possible based on how this exists. We would also need to categorize who is disclosing and what category they fall into. And there would be 3 ways, as I understand it from our council, to proceed. Either remove the requirement entirely, reduce the scope of disclosure, or maintain it as is. And if so, we would be using a November timeline.
A November timeline. Thank you. What I want to, the second question I have is what I want to follow up with is I reviewed the videotape and also an email from Dr. Rollins, which states it's not due to a lack of transparency from committee members, but time constraints to prepare the form. Council confirmed the 700, for the filing date, April 3rd. So again, we have learned that there is no time constraint, and that what I am restating is that I myself had a month to file the form. So can you clarify what happened here, that on Thursday of last week, some members had not seen the form. It's suggested to me that some members had not received the same information that I received. So can you walk us through why a week ago this committee was in that situation with a board bylaw that stated 700 had to be filled?
Because we did not know the information a week ago. And so it was our understanding that they would be on the same timeline as you. This is a new committee, the first time that this committee has been formed since 2009. And so it was not within our realm of understanding of all the steps that needed to be taken to have the CBOC members do the form. I would also clarify, though, that in watching the CBOC meeting, time constraints was listed as one issue, but that was not the sole issue of the committee.
Okay, and my last question is, again, if the this committee was approved by the prior board upon which I was sitting in November, and in March 17th, they received this documentation. Again, are you saying that our district did not know that the Form 700 requirement was sitting in the CBOC bylaw? Because if you knew it, then you would have unknowingly sent it to them in the same process upon which we have all been involved for a month. And if you didn't know it, then it would make sense that they would not have received it. So can you speak specifically to that for clarity?
Every other year, we're required to put forth to the County Office of Elections who is required to do that form. The last time it was required of our district was June of 2022. The board did not form this committee until November of 2022.
Okay, thank you. Questions?
You actually also a lot of them. The CBOC had a meeting in December, right? Okay, and the agenda looked exactly the same as it did for March 16th or no. Okay, it wasn't the same because I could only see on a our agenda or assembly. I could only see the CBOC meeting from December agenda, but there's no minutes attached. So
They haven't been approved.
they haven't been approved. Okay, all right. Did this come up then? 700. It was in the agenda, I thought, like the bylaws and everything, but it wasn't addressed.
Draft minutes, it did state that the members were given the bylaws and requested that they speak to staff if they had any concerns.
Okay, okay. So from December through now, no concerns. Now being the
There
CBOC.
were additional concerns, and so that's why we had the same bylaw discussion again, and not the same topics. But we brought back our legal counsel for the CBOC because there were questions about other parts of the bylaws.
Right, do those questions come up just before the CBOC meeting, or do they come up in January, February?
They came up, I would say shortly after December. I don't know when to
Okay,
track
but
those.
they weren't addressed again until the.
Not
meeting,
until the board could come together again.
The-
They needed to
The
be
committee meeting. on
addressed in public.
Last Thursday,
Mhm.
right, okay.
Mind if I ask a quick procedural question?
Please.
So I'm a little confused here because the purpose, as I understand of this first part, is whether or not to have the Form 700 requirement, which is not legally required for the CBOC members. And it feels like the conversation has already gone to step 2 of the timing of when it might be due. So I feel like we need to first address the question, which is whether or not we want to require this requirement for CBOC members. And if the decision is made to require it, then turn to timing.
No, we're talking about, we're asking questions relevant to why we're sitting here today and the request before us. So it is the request before us, we are learning through questions and through the emails that we received since Friday, that it is not just about whether the Form 700 should legally or not legally be there. So we're going to continue the round of questions, and then during discussion, you can certainly advocate, Trustee Abdoli, for your position or at that time. But let's continue with questions to ascertain the reasons why there was a request, so that we're very clear on the data as we move forward. But thank you. Yes, we do have a legal. We have lots of thorough legal evaluation. We're getting the other data as well. So other
That's it,
questions?
so that was my question about what
Okay.
happened between first meeting and the second meeting.
Okay, so Trustee Abdoli, do you have any questions?
No, I think the multiple legal memos on this topic were sufficient.
All right, and Trustee Yu.
So as a newbie, I just want to know in this Form 700, when you need to disclose it. If you don't believe you have any conflict, it's a very simple document to fill, just sign. But when do you consider you need to fill in all the details? I think that clarification, might help some people. Understanding that you only need to fill in when you have direct conflict or you own something that you could, who's direct, let's say you own a stock and you could influence the direction of, that company, for example. So can you clarify to us when we need to fill in? Or when we need to disclose specifics? I'm talking to our attorney. Yeah.
Okay, yes, I'll chime in. So the specific disclosure requirements are typically governed by each district board's or in a school district context, that's conflict of interest code. As Dr. Berman briefly mentioned earlier, this district's conflict of interest code currently does not identify CBOC on its conflict of interest code and the relevant disclosure categories. And so that would be a necessary step to identify those members as to what types and to what extent their disclosure requirements would be, should you keep the Form 700 requirement. Typically, the disclosure categories vary based on the type of decision-making authority and powers and influence that a particular official, employee, or board member or other agent of the district would have. And so the conflict of interest code is laid out in a way where you identify the different types of categories of employees, and then for each group, you would identify their applicable disclosure category. And so that would be kind of would be the governing document essentially that governs for the CBOC as to what extent that they would have to disclose. And then based on that disclosure categories, if an individual CBOC member, has certain assets that fall under those required disclosure categories, then they would need to provide that information as part of the Form 700 and the attached schedules.
But can I just
So you're
clarify?
not-
I heard a different question a little bit from Yoonhee.
That's
for us as
wasn't my
board
question.
members-
Trustee Abdoli, hold on, let Young He's trustee use gonna clarify your question.
So
Thank you.
my issue is, yes, I understand that they're not in the direct decision making. So that category wasn't what I was asking. I was asking, so for example, for me, when do I disclose? Because I have, how do you define conflict is what I want to know, because depending upon how you view conflict, right? I mean, so I own a little stock in McDonald's and there's a McDonald's in Mill Valley. Does that mean I have to disclose, right? Like how direct does the conflict have to be for people to have to disclose?
I don't know if I can answer that directly without confirming the exact legal citations and your conflict of interest code. It would be as defined in the Political Reform Act and relevant regulations. That would be what's the governing body of law. Unfortunately, I just don't have the specific definitions.
I'm happy to chime in. 87-200 requires all elected officials such as us to complete all disclosure categories. So we cannot have lesser disclosure categories than CBOC. So while CBOC can have narrow areas, so you need to your question, we are required to disclose all interests that have any tie to the district, regardless of whether there exists a conflict of interest. So for example, if you own over $2,000 in Apple stock and the district does business with Apple needs to show up on your Form 700. If you are high, so it's anything
district
tied to the district.
So how do you say, what's the definition of tied to the district?
Trustee, I
because-
just want to make a point of comment. So we have trustee Abdoli providing legal guidance now. And trustee Abdoli is not on our approved list of attorneys. And the information I'm receiving right now is actually, I can say personally, in direct conflict with what I understand in terms of the form filling, what to fill out. So I think that we may need to have further legal guidance on this for our Form 700.
Yeah.
Unless Anna Russell or Kimberly Berman, you can share specifically, because that is not what I understand. And I've been filling this out now for 3 years. So can you provide some clarity to this now?
Yeah.
Or should we get some legal advice on this specific issue?
That is outside the agenda item of what is being considered here, but we're happy to set another agenda with this topic and training for the board.
Okay, so then
So-
let's move on.
Just to
No, I-
quickly add in, I recently filled out this form. I personally called FPPC about my own personal questions. So while we are responsible for all disclosure categories, I think because of the nature of it being so individual, I don't think that it benefits the board to have another meeting or training about this, and would be more beneficial to reach out to FPPC individually for questions related to one's own situation and any potential disclosure requirement.
So let's go ahead and
The reason why I
Mhm.
ask this
Mhm.
is I wonder if people view this as being onerous because they're under the impression they have to disclose everything under the sun. But if the legal definition is directly doing business with, my understanding is if you own a shoe store in downtown Mill Valley, you are not doing direct, business with the district.
No.
So
Yeah.
is it like if the business is within Marin County, or is it, the Marin County or district does business with? That's what I'm asking. It's
and-
not, I mean, personally, I have no conflict. I did talk to FPPC and Dan Miller, so I'm aware of what I have to do. So I'm doing it so that I could understand how onerous this is for people to fill in, and why people might view it as something impossible or really difficult to do.
So I would recommend then that we table that be an issue, but we don't go into that issue because that would be outside the scope of what we agendize for the conversation.
Well, for me, it will help me determine whether I wanna put this, I wanna, vote to require this or not to require, because for me, I just wanna understand if people clearly understand why this form is needed and what they need to disclose, because it's as simple as oh, it's something you could, the district does business with, so you have to or it's more broadly defined. Anything that's in this, the district, like owning a McDonald's stock, share McDonald's stock, and there are McDonald's within Marin County, you have to disclose. It may be entirely different thing, because I'd be more sympathetic to not maintaining if it's like every single thing under the sun, but I may be thinking, well, if it's something as simple as only disclosing conflict in situations you have control, there are two very different disclosure requirements.
Can I ask a question or no?
No.
Okay.
So can you, legal counsel, I am hearing potentially, if you can, if you can clarify now, great. If not, then we will need some more clarification.
I'm just
Let
saying,
me finish. My understanding is that trustee Yu may have some misinformation when she uses the term Marin County. My reading was within the district boundaries, which is Mill Valley.
Yeah.
And so can you clarify that, please, for us
Oh, that's
before we
yours.
move on?
Yeah.
Yes,
Plus
so,
two hours.
based
Let's see
on,
if she.
so based on the district's conflict of interest code, the governing board members are subject to disclosure category 1. And that identifies your disclosure information as to interests in real property, et cetera, that are within district boundaries, not county, within district boundaries,
Yes.
and what, et cetera. And so it goes on. And so it uses the district as kind of the parameter for purposes of the governing board members' disclosure. And then just to briefly supplement, that's where what I was mentioning earlier about the different categories. So category 1 is this kind of broader district related category disclosure, which applies to the governing board, but there is also a different category 2 disclosure category within your conflict of interest code, where for certain positions, the disclosure category may be slightly different and modified based on their respective decision-making capacities and authority and things like that. And so depending on which designated position that you fall under, you would need to identify what your disclosure category is. And then if you do have any, financial interests, investment, et cetera, that are required to be disclosed that meet the particular definitions of your disclosure category, then you would need to comply and provide that information.
So then the follow-up is we've had this board bylaw since November, which was provided by your organization, not your organization, but in concert with another attorney firm that we use. And so when this was approved by the prior board in February 15th, what disclosure category is understood by you that the CBOC members fall under?
So ultimately, I think the bylaws that were adopted were by the district had worked with a bond counsel, if I'm not mistaken. And so that's the set of bylaws that ultimately were adopted. And so we were not involved in the finalization of those board of the CBOC bylaws. Typically, anytime typically if you have different positions or groups of positions that are created that might be subject to the Form 700, then the board can modify its conflict of interest code to identify new designated positions and or to modify the category descriptions. And so it wouldn't automatically always be that you have to fit somebody into one of the listed designated positions, but you can the board could take steps to modify its code and to add new designated positions and or to modify category requirements, etc. And so that would be a general process, not only for a CBOC, but when you have positions wherein you may need to that may need to file the Form 700.
Thank you. Do you have any further
Yes, I
questions,
do.
trustee?
Yes, I do. That's a follow-up question.
Mhm.
And then you brought up in your beginning, your intro, you bringing down the scope of the disclosure. So how would you bring the scope down? Assuming that, the CBOC members don't really make any decisions.
Did you want me to chime in or was this for
The
Dr. Berman?
disclosure scope, yeah, reduce the scope of the disclosure. How would you reduce scope?
So I think we want to be cautious. So in terms of not necessarily, so we wouldn't necessarily be reducing scope because right now the CBOC is not identified as a disclosure category, but because they don't hold the same, decision-making authority as board members or the superintendent, for example, and are, as explained in the legal opinions, acting in an advisory capacity. If the district board, wishes to maintain a Form 700 requirement, but in recognition of the committee's, limited advisory capacity, instead of having this very broad disclosure category apply to the CBOC members, the board, in conjunction with district staff and legal counsel, can draft an alternate category that could apply to the CBOC and similar other advisory oversight type committees that don't have decision-making authority, where you could potentially identify a much more narrow disclosure scope for these committee members. And that would be kind of a balancing act of recognizing we do want, committee members to file a Form 700, but we recognize the very limited scope of, if any, decision-making powers that they hold. And so we would, limit the amount of information that they would need to disclose with their Form 700. And so that was, I think, what Dr. Berman was initially introducing when she mentioned the brief 3 options at the start of this agenda item. And so it would be, a process by which we would determine what could be an appropriate disclosure category where possibly, the scope is not as broad as some of these other designated positions because the committee members are acting in this limited oversight advisory capacity.
Thank you.
My
One last
third
question?
question,
Right.
my third, so half the districts currently require, Form 700, from CBOC members, but, the other half don't. So of the districts that actually require Form 700, what kind of disclosure do they typically require? Is that the same requirement as category 1, like the board members, or is it something much more watered down version?
I unfortunately can't speak to that. I don't know off the top of my head as to what disclosure categories that they would apply to the CBOC. We could certainly look into it and follow up if that is the course of action that the board would want to take. As Dr. Berman mentioned, because the filing deadline, we've gotten written confirmation from the Catamaran Elections Department that it is possible to push back the deadline to November for the reporting. And so there would be time for the board and district staff in our office to review kind of alternate options of disclosure categories if necessary. And if that is the direction that the board ultimately decides to move in, and then we could work with you to present options and discuss what other districts may have done in similar instances.
Yeah, all right, thank you, that's it.
Trustee Nick Katz.
Can you please confirm that CFAC, which is similarly an advisory council committee, does not have the Form 700 requirement? Is that accurate?
That is correct.
Okay. And for Measure C, it was in place before to have Form 700 required, but then it was then pulled back after review. Is that correct?
That is correct.
Okay, those are my only questions.
Okay. So now we're going to move to our discussion and advocacy. And I think it would be, for efficiency's sake, helpful if we could state our positions. And if we have any follow-up questions or comments, that we keep them as clean and crisp as we can. And then following that, there will, I'm sure, emerge a motion for a vote. So I'd like to begin by first saying that, as I mentioned in an email to all CBOC members, I am thankful and grateful for your volunteerism and your willingness to provide oversight on a very important bond, the biggest bond that our a city and this district has ever seen. So we really do appreciate your efforts. And I can say that in informing my decision, I did listen intently twice to the video. And I learned that there was one member who felt that this form, as they perceived it, is onerous and hard to fill out. I heard from the current interim, Roger Peters, who is married to a politician, that he knows that he's got to fill this out and has success and familiarity with it. And then there was another member who had indicated that he had filled it out and it was fairly straightforward. So I did hear various opinions. I also did hear that some members apparently had not known about the form and were surprised. And I sensed some confusion and concern about the form. And I understand now, since they were not provided the same scaffolding and support that board members are to Form 700, and that our district didn't research until this came up. I want to apologize on behalf of the district to CBOC, as I feel that there was this false feeling of rushness. There is no April 3rd deadline, as we've learned. However, it would have absolutely made sense. And in our protocol, as Anna Russell so professionally puts out, we get a full month in which to digest this form and fill it out. So I have heard that we can very simply legally make this change, but I think it's more about public perception of CBOC and its relationship to the board. And I know that in my talking to constituents and listening to concerns, transparency now, as our attorney says, since Prop 39, has been a growing movement of increased governmental transparency. And these bonds do relate to though not public officials, you provide an oversight capacity as a support organization to this board who must direct, these funds. So I understand the concern. I heard from one member. I was looking forward to other letters from the board, the CBOC committee regarding this, and we have received one public comment and one letter. We do have 3 alternates and 7 active members, and I am assuming that they also read Form 700, and I am also assuming some of them may have filled them out and already provided them to Anna Russell. We didn't receive that information yet. I want to say that there's no time constraint. I know that was a big part of the concern. And I do want to confirm, however, I'm a little confused. So the point of clarification, Dan Miller's email back March 29th at 1:24 does reply that since we're filing official for this committee, we're the filing official for the committee, we can certainly extend, and he has agencies that begin their annual in June. So I'm feeling that June provides ample amount of time, and it sounds like there has been a fix, and this request and concern, though again legally seems like an easy fit, for me has serious consequences as a board member to my duty to provide oversight and accountability. So for me, raising the bar with other districts in the state seems to be an appropriate decision. I also want to identify for the record that I was not at the September 15th meeting, so I did not vote on this. And for the record, neither did Marco Pardee, but Trustee Abdoli here today, Emily Uhlhorn and Marco Pardee were the Todd May, excuse me, were the 3 board members who voted on this bylaw September 15, 2022.
I would like to clarify that the bylaws came forth with the resolution in September. However, the acting bylaws are the ones that were adopted November 3rd, which are different.
So the acting bylaws, however, the September 15th is the date when the bylaw was
First
incorporated.
adopted,
Yes,
and then a different bylaw was adopted in November.
so can you point of clarification, were they different?
They were.
And
What changed?
yeah, why was that? That's
The
new information.
bylaws in September came from F3. The bylaws in November came from our bond counsel,
Mm.
Jones and Hall.
So which one was adopted?
The ones that came last would be the ones under adoption.
So I was in misreading your email. So in November, trustee Abdoli and myself were a part of the board. Okay, so that particular document, then can you please share with us what the vote was? Just so we have clear information, you know.
I personally don't need to place blame on things, so I'm fine, but clearly. it's
Trustee
a concern
Abdoli,
of
I'm
mine.
making a point of order here. You're creating that statement is specious and somewhat attacking. Can we just get the
Personally, I
information?
find your intent to try to pick who's voting for what back in September when we have a current vote.
Trustee
Similarly,
Abdoli,
I'm
we're
tempted
just
to attack.
We're just putting in the record we're putting in the record how this came about and who was involved.
So you all voted in favour, the whole board voted in favour.
Okay, so the whole board at that point voted in favor. Thank you very much.
Okay, so I concur with a lot of what you said, so I'm not going to repeat it in the interest of time. My understanding was that this was unanimously supported by the previous board. I was there at the CBOC meeting. At first, it wasn't what the issues that were brought up were not necessarily related to timing. But then timing was thrown in as the reason to all of a sudden schedule this meeting pronto this week, find a time. And now we've since learned from Dan Miller, timing's again, not an issue. So given that, let's, one of the arguments in the opinions we got was that this was defensible in a court of law, but why put ourselves in that position? I'm not comfortable with that. We are always striving for better transparency, more transparency. This is the biggest bond we've ever had. And I think it's really important to make sure we are above all above board on this. So I am in favor of keeping the Form 700 in the bylaws.
Trustee Abdoli,
Am I okay to talk, or are we gonna jump down my throat?
again, that's an inappropriate comment, can be reserved
Well,
for a private
it's
conversation.
definitely been a
Can you
lot of
please stick to
jumping
the-
in and
Thank you.
interjecting and really being dismissive, so lots of inappropriate comments.
Again,
here.
I'd appreciate if you could give us your
I would love to.
advocacy
Let
and
me
discussion.
have a moment
Thanks.
to
Thank
speak.
you.
So since this was not a requirement for the prior bond committee, it is not legally required. I don't see a reason for it to be required here. The very concept of Form 700 is to identify disqualifying conflicts of interest, which would preclude the person completing the form from making a decision. The CBOC, by its very nature, does not make decisions. So it should never have been included in the first place. The prior board did identify that it should not have been included with respect to the prior bond oversight committee and removed it and corrected the issue last time. And I believe that we should do the same thing, because of utmost importance is encouraging public participation. So anything that would stifle such a participation on the CBOC board is a huge negative to me. Further, something so arbitrary, why not request their driving record? I mean, it's a document that provides us no legal basis to do anything with respect to their official roles. So ask for their driving record, ask for their criminal history. I mean, you might as well ask for a whole bunch of requirements that are unnecessary. So I would absolutely oppose or support removing this requirement.
Thank you. Trustee Yu.
So my concern here is timing and the amount of bond issuance. It's $195 million. I would prefer that our district be the half of the the districts in California that has enhanced transparency. But here's the issue. I felt like we didn't take the right steps. I think first we need to identify the categories of CVOC members and where they need to fit in. And then maybe reduce the scope accordingly, because it just seems like it wasn't done right in the first place, and we caught it on time, and we have a lot of time. So I think maybe the discussion to have is not to keep it as it is, but to create a category and then design, or, you know, I just would like to first see, I just want to be the top half of the districts in California in terms of transparency. So I want the Form 700. But I like to understand what are the typical requirements for CVOC members, whether it's a full category 1 disclosure or some other disclosure. So if we are not given choice of you know, reducing down the scope, I would say to keep it, but to the extent that, you know, that we can reduce the scope to be something a little bit more practical, then I think that's the route we should go for, while maintaining, you know, our transparency. My concern is we were, you know, I've been in enough business litigation to be like the perception matters a lot. And there may be some people who are not happy about Measure G and they saw the video of CVOC. And let's say there was something goes wrong with this project and there's some conflict, it turned out, then I don't want to be in the situation of, oh my God, we didn't disclose it. So maybe, you know, bringing down the scope might be a good compromise, you know, that we could still say we were transparent and still, you know, make it a little bit more practical for potential members of CVOC.
Thank you, Trustee Yu. Trustee Katz.
I don't think that we should hold CVOC to the Form 700 requirements. I think that it's important for us to be consistent in our approach across the district with committees that we're having involved, and not just saying we're checking a box on transparency. I think that the purpose of having that transparency and ensuring that there is compliance from an ethical standpoint is already taken care of with the ethics and conflict of interest policy that they have to agree to in joining the committee. There's no decision making that is part of this. And frankly, at the end of the day, you could say you have to fill out this Form 700, but it's kind of a practice where you have to trust that people are being fully open and honest and disclosing everything. So I think that we're already getting what we need with a group that is not responsible for making any decisions, unlike our board and our administration team, where that is different. And I think the conflicts are different. So while the scope is very large with the bond oversight, at the end of the day, they aren't holding the decision making. So I think keeping something that I absolutely agree with you, Yidhi, about your comment before about, for some people it might be onerous, for others it might not, and it's very, very much an individual thing. I don't think that we should make decisions based on how difficult it might be, but what is the overall intent, and is this served in another way, which I think it is. And so I would push to remove that requirement for CVOC.
Can I ask you a question? Would people be open to creating a new category and watering down the scope of disclosure? I'm trying to have my cake and eat it too here.
No,
So
Uni, I would love to make that motion, because that's actually hearing you and hearing the motion that I was thinking of making is that they would be category, a new category, and Schedule D would be their disclosure. That would be, I move that we create a category for CVOC and the disclosure be Schedule D.
And Ellie, what is Schedule D?
Schedule
We
D
don't know
is-
Schedule D.
yes. Schedule D is gifts. It's
Yes.
the only category that could have any. So like if AECom goes and flies or wines and dines are CBOC members, that's the area that creates concern when your actual potential vendors might be doing something becoming with your board members. So given that that's
Or
the
you
area.
own. Yeah, or you own a concrete supply company and, you know, you are trying to, you know, sell concrete to AECom. Like, I think that if you own McDonald's stock and, you know, we have one McDonald in the district, you shouldn't have to disclose it, but if it's like, if it's like you own a concrete business or you own a construction, you know, subcontracting business, you should disclose it, you know, but I just think that's more practical while maintaining that, you know, while protecting our district and say there's absolutely no conflict. You know, it is create a separate category.
So
That's my
I'm
motion.
not
Did I-
adverse.
Sorry, so I presented a
I'm
motion.
not. Yes, but we don't, can I ask a clarifying question? Because I don't know what Schedule D looks like, so I personally, if we had that information here in front of us, I'd be able to make a quick decision, but
It's
there-
one of
you
the
know,
pages.
so
of
I don't know
Form
if it's available.
700. So you probably what you just looked at recently when you completed it. It's one of the.
Yeah, it's like what, the last one. It's
Second
not
to
the
last,
stock
yeah.
one, it's not the real estate
Okay.
one, yeah.
So there's a motion on the floor to, could you please repeat your motion?
Sure, my motion is that CBOC board members would be in a new category, and the disclosure for that category would be limited to Schedule D. I'd be happy to reference what all the other schedules are, but I also don't want to.
And
Yeah.
I have it right in front of me, so I'm happy to read aloud what
So,
it is,
okay,
if anybody's curious.
Can I just talk freely without being within the motion?
Right, well, partly, you know, you're interjecting a motion without us having the information, and I myself am concerned about that because I don't have it in front of me. And the other piece is that we have Jones Hall, who's not here today, who actually was the author of the motion,
Oh, the bond.
the bond,
The bylaw, sorry.
and the document. So
I do want to say that they were responsible for the resolution and bylaws. They said that we needed our general counsel related to the Form 7.
okay,
Jones Hall does not have the
Oh,
expertise
thank you.
on the 700 form. And so I had a phone call with Courtney Jones yesterday. She said to consult our legal.
okay, so she gave you,
The bylaws and the resolution.
okay, but regarding Form 700 that's in that they put in, they don't have any expertise related to that particular. form.
Correct.
Okay. So I
I'm
think we
happy
need to
to
have some
mention what the
discussion on
other
the Schedule
categories
D.
are. Yes, I'm happy to
And then we
mention what
need
the
to have
other
this dis-
categories are if helpful.
Could you please?
Sure.
You know, I myself like to pause
on.
for a moment.
Hold on.
I'd like to pause for a moment because we were here and there's a suggestion of modifying, but we need some legal counsel in terms of what the request that you had made, Young Hee, was to have legal follow-up on what other districts provide this, of which perhaps F3, you know, you had mentioned, you don't have specifics, but there are districts that have this in their bylaws, and that information to share with the board on what is the process or protocol or common response for reducing the scope could be shared with this board. Most likely not today because it's a new request for information. My concern is we've got new information. We are required by law to provide the community the same information, legal information we're getting. We're now getting schedules that we need to read. So I'm personally not comfortable having a motion on something and drilling down and getting the specifics. I'm happy to discuss. I'm happy to discuss and have us discuss the idea of reducing the scope. But in terms of getting the specifics, it seems like our public also needs to have the opportunity to see what we've come up with.
Although it seems like we were prepared to potentially pull it all together. And so,
So I think a motion to pull or a motion not to pull with maybe some modifier makes appropriate sense, but to pull and modify with some specifics here about schedules that are legal
But this,
documents
Michelle,
that.
would you prefer that I modify my proposal to say, we propose that we withdraw the Form 700 requirement temporarily until such time that we have identified the narrower scope of disclosure categories or the specific scope of disclosure categories for CBOC members?
Yes. What, so can I?
if you make that motion, I'll second it.
That's my motion.
Can
I move that we
I-
I
follow the
second.
Form 700 requirement until we can identify the disclosure categories for specific for CBOC members.
So,
I second.
Okay,
well, I'm not ready to make a vote on that yet. Can I ask the attorney this question? I mean, am I wrong in thinking we should have created the categories for CBOC members in the first place? Because there is not,
Yeah.
they're not category one, right? What other categories are there? I just want to first understand it before we pull anything. So can you answer what categories there are in our district? Can anybody? Because I think we first need to understand the categories before we put people in. I mean, I don't think they were ready to sign anyway because they, you know, the CBOC members did not belong to any category. So shouldn't we
And just
first
to be
decide
clear,
that
you know,
first?
my proposal is that we would be determining what category, whether it's creating a new category or using one of the established categories. So we're not, my proposal does not say it is this category. It just says we will determine what category they will be.
Yeah,
but my concern with
And
that
there's a
is that.
second, so isn't this how to procedurally?
Procedurally, I think
So would you please repeat what you're, because the
Sure.
motion is adding new information that creates more questions, so that's part of the challenge here.
So
It's
my
not a clear
motion
motion.
now is that we withdraw the Form 700 requirement tentatively until we can identify the disclosure category for CBOC members, at which time we will both identify the disclosure category for them and also provide the due date at that time so that they will have ample time and heads up on their category and the timing of their Form 700. So
And
to
is
be
there a
clear,
so I agree with her, but I would like to add one thing. I like to determine what disclosures are needed because I think GIFT should be one of those.
But so what
But-
she's, I
yeah.
think what her
that was my
motion is
first
that
proposal.
is a
Yeah.
process.
Yeah.
Which would need to be facilitated by an attorney so that we understand the
What that-
difference
yeah.
and can adjudicate that
Yeah.
appropriately at a later date. So is there a second?
I will second.
And do we have the written specifically what this motion is? Can you repeat it so we're clear?
A requirement, sorry, pull Form 700 requirement until identifying the disclosure category for CBOC categories, at which time we will identify the category. I think I typed that three
And
times.
disclosure,
the timeline.
and disclosure requirement.
Well, that's the category.
Yeah. And
So
then,
there's no timeline on this motion, though. There's no timeline in which the board is to address this.
Correct, because you have said, as Dan Miller indicated, we're allowed to set whatever timeline we want. So when we hopefully bring this at a normally agenda or regularly session meeting, we'll be able to at that time address it,
We
have a
to-
proposal, have the timeline.
And so we do have until November legally because we had a June
It
date.
is supposed to reflect a 12-month disclosure. This committee was not formed until November of last year. So at this point, your disclosure would be very limited within that.
Okay, so are we clear on the motion?
I
Yes,
am,
and
I,
And I've
And there was a
seconded.
second. All in favor?
Aye.
I oppose it only because I
Wait a
agree.
minute, all in favor?
Sorry.
All in favor again, because there was some disruption. All in
Aye.
favor?
Aye.
Aye.
All opposed? Aye.
Oppose. Can I
Okay,
state why
so-
though? I just want to state why.
Well, if you want to state for the records.
For the
please
record,
feel
I
free.
say, I support this idea. However, I would maintain this Form 700 in the meantime. Keep it as is while we revisit, and I like the idea of revisiting, reducing scope, getting more clarity on where CBOC members fall in these terms of these categories, but I wouldn't pull it. That's why I voted.
Well, does it even have
And
to
that's
be
why I opposed
tentatively pulled? Can we just then, so just to say we
We already
agree,
voted.
we do not have,
We
No,
had a
it's-
vote.
it
yeah, we-
passed.
sorry,
So-
sorry, for me, it was like
So-
arguing semantics. It's tentatively. I would like to make it very clear what I voted was tentatively. Right, as long as that word was in it,
It was that.
or temporarily pull, because it's delayed temporarily pull to me was all semantics.
So maybe
it's
can
better
you
to-
reread it again?
Yeah.
Because, well, please, what you have written and make sure.
What I have written is slightly off what she
Thank
said,
you,
but
Anna.
we have the recording.
Okay, very good.
But I will make sure that it is word for word.
Sure.
The word tentative was in there.
Okay, all
Can
right.
we say tentatively for sure? Can you? Yeah,
Yes, I will attest, I did say tentatively.
and that's what I voted on, which to me is like delay
Okay.
the requirement, whatever. To me, it was all semantics. So,
Thank you.
but it gets to the same place. I'm not agreeing to pull it at all permanently. Yeah.
All right. Well, thank you. So I think this concludes our board meeting, and we have direction now for the district and CBOC members. So
Yeah.
I'd like to adjourn this meeting at 2:03 PM. Thank you.